Marsha Thompson's experience with firearms and her experience as a law enforcement officer. Does that indicate to you sort of against the battered spouse finding?
No, ma'am, be the opposite.
What is coercive control?
So it's a psychological way that batterers control their victims. It's a way that they get acquiescence and obedience from them. It can be like telling them they can't be around certain people, or accusing them if they're too friendly with certain people, they're having affairs with them, or controlling what family members they can talk to, or demanding that they answer their calls immediately, no matter where they are, what they're doing, that immediately you respond and answer my calls, or controlling their money and what they can spend, and where they go and who they do it with. All of those things are examples of coercive control. It creates helplessness in people. It's a way of managing and dictating to them what they can do and can't do. And that creation of powerlessness results in them being willing and submissive and willing to tolerate things that they ordinarily may not tolerate.
Was Marsha Thompson experiencing coercive control in her relationship?
So very much so. So all of those tactics were employed, and that's oftentimes what batterers do, is they engage in coercive control of a victim to be able to get them to do some of the things we've talked about and stay in the relationship. So whether it's sexual behavior or physical abuse or demanding what they do or don't do or how they take care of them, all those things are part of coercive control. It's a way of demanding and maintaining obedience in the person who's being victimized.
So given this coercive control, as well as the cycle of violence that you talked about, how is it that a person or a woman who was, let's say, educated, intelligent, that she would get caught up in this?
There's a difference between our education and what happens in our brain, what we call cognitively as psychologists, and emotionally what happens. So what creates your emotional bonds is a big part of you as big terms of your psychology of a person. So if your psychology is what's important to you is forming a relationship, a loving relationship with somebody, and forming a family and staying within that family and not having things happen to you like what happened during your childhood with your parents, you kind of don't look at the brain part, the intellectual part, you look at the emotional part. What keeps you stuck is the emotional part. And then if you add to that a fear of what will happen if you go against that, that can keep a very smart person stuck in a very abusive relationship. And that's what oftentimes happens with women who are victimized. Women who are victimized aren't always people who don't have education. They're not always minorities, although there's a pretty high percentage. They're not always people who are helpless and don't have resources. They're people who have been psychologically coerced into a belief that they're helpless and can't do anything about their situation, and they have to survive.
Now, when you talked about the hypervigilance and sort of the autonomic nervous system,
Yes, ma'am.
People might know that as fight or flight. Is the person, the victim, is she living in a state of fear?
So there's a constant concern and fear that something bad will happen. So when you're in that kind of combat situation where bad things can happen all of a sudden, even the quiet times aren't really quiet times. So what looks like a period in which everything's okay isn't okay, because you're hyper alert and knowing that bad things of a different variety, not just one thing, but a variety of things can happen to you. So your hypervigilance really doesn't give you much downtime, much peace, much ability to be able to say, I'm okay.
Big takeaway, domestic violence can have lasting, long-term effects on one's health, one's brain. We're going to see the cross-examination of this tremendous psychology expert next.
I thought maybe it's better if I die and this is all over. But then I worried about the kids. I said, I can't do that to them. I have to try to protect them too.
Did you want to live?
I did.
Did you stand your ground?
I did.
Were you in your head?
Welcome back to Court TV Live. I'm Ted Rollins, glad to be along with you on a Friday as we round out another week here at Court TV. Testimony continues in Palm Beach County, Florida, in the abused wife or murderer trial for Marcia Thompson. She testified that her husband, Terry, was threatening to kill her during an argument in their home in August of 2019. She claims that she was defending herself and that she had suffered years of abuse. The prosecution claims that Terry was unarmed, laying out
which were not offered and received into evidence are not available to you. The following are not evidence. 1. Statements, arguments, questions, and comments by the lawyers. 2. Objections and rulings on objections. 3. Any testimony I told you to disregard. 4. Anything you saw or heard about this case outside the courtroom. Instruction number 6, in considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 7, decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, 1, whether the testimony is reasonable and consistent with other evidence you believe. 2, whether a witness has made inconsistent statements. 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 8, you must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all of the applicable law. Instruction number 9. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 10. The burden is on the state to prove Tyler Dazey guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, and not the mere possibility of innocence. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if, after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. Instruction number 11, if there is a reasonable doubt as to the degree of the crime, The defendant shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 12, the duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 13, where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. Instruction number 14. To commit a crime, a person must intend, the person knows the act is against the law. It is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 15. The state must prove all of the following elements of murder in the first degree. 1. On or about the 18th day of January 2024, the defendant struck Jennifer Dazey with a dangerous weapon. 2. Jennifer Dazey died as a result of being struck with the dangerous weapon by the defendant. 3. The defendant acted with malice aforethought. 4. The defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Jennifer Dazey. If the state has proved all of the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree, explained in instruction number 21. Instruction number 16, malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another, which exists before the act is committed. It does not have to exist for any particular length of time. Malice aforethought may be inferred from the use of a dangerous weapon. Instruction number 17, willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Instruction number 18, deliberation and premeditation need not exist for any particular length of time before the act. Instruction number 19, if a person has the opportunity to deliberate and uses a dangerous weapon against another resulting in death, you may but are not required to infer that the weapon was used with malice, premeditation, and specific intent to kill. Instruction number 20, a dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device which is actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. Instruction number 21, the state must prove all of the following elements of murder in the second degree. 1, on or about the 18th day of January 2024, the defendant struck Jennifer Dazey with a dangerous weapon. 2, Jennifer Dazey died as a result of being struck with the dangerous weapon by the defendant. 3, the defendant acted with malice aforethought. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter explained in instruction number 23. Instruction number 22, murder in the second degree does not require a specific intent to kill another person. Instruction number 23, the state must prove all of the following elements of voluntary manslaughter. 1, on or about the 18th day of January 2024, the defendant struck Jennifer Dazey with a dangerous weapon. 2, Jennifer Dazey died as a result of being struck with the dangerous weapon by the defendant. 3, the act was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter explained in instruction number 25. Instruction number 24, concerning element number 3 of instruction number 23, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his or her passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Instruction number 25, the state must prove all of the following elements of involuntary manslaughter. 1, on or about the 18th day of January 2024, defendant recklessly struck Jennifer Dazey with a dangerous weapon. 2, the defendant struck Jennifer Dazey with a dangerous weapon in a manner likely to cause death. Intent, as used in these instructions, means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 27, for count 2, on the charge of animal abuse, the state must prove element 1. 1, on or about the 18th day of January 2024, the defendant intentionally, knowingly, or recklessly inflicted serious injury or death on an animal by force, violence, or poisoning. 2, the defendant cannot be found guilty of animal abuse if any of the following apply. A, the act was the euthanizing of an animal that was in a state of permanent pain or suffering and done by the owner of the animal or someone acting with the consent of the owner. B, the act was carried out pursuant to a court order. C, the act was an act of veterinary medicine. D, the act was the hunting or trapping of a wild animal. If the state has proven element number 1, and if you find that none of the circumstances exist under element number 2, the defendant is guilty of animal abuse. If the state has failed to prove element number 1, or if you find that any of the circumstances exist under element number 2, the defendant is not guilty under count 2. Instruction number 28, euthanasia means the humane destruction of an animal accomplished by a method that involves instantaneous unconsciousness and immediate death, or by a method that involves anesthesia produced by an agent which causes painless loss of consciousness and death during unconsciousness. Instruction number 29, the term serious injury, as used in element number 1 of instruction number 27, means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or extended loss or impairment of the function of any bodily part or organ. Instruction number 30. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's age and experience, the reasons for the opinion, and all the other evidence in the case. Instruction number 31. Evidence has been offered to show that the defendant made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence, just as if they had been made at this trial. Instruction number 32. In this case, the defendant has decided not to be present and not to testify. The defendant is neither required to be present nor to testify. No inference of guilt may be drawn from these decisions. The burden of proof remains on the state to prove the guilt of the defendant beyond a reasonable doubt. Okay, that's where we're going to stop, and we'll pick up with instruction 33 after closing arguments. Consistent with how trial has proceeded, the state has always gone first. The state has the burden of proof. The state will go first with closing argument. When the state is finished, the defense will have their opportunity. When the defense is finished, the state has one last chance to come up and rebut anything that the defense said in their closing argument. So, Mr. Nelson, with that, whenever you are ready, go right ahead. Yes, please. Yes. Do you know what number that one is by any chance? Number 1.
May it please the court,
Counsel.
ladies and gentlemen. First of all, I'd like to thank you all for coming in here and giving us your time. I know there's a lot of things you'd probably be wanting to do on a nice week like this, great weather, but this is a very important function, and we do thank you for coming in and giving us that time. Secondly, I'd like to thank you all for paying attention. Sometimes things get a little boring in here, and I was watching, everybody was pretty much locked in as the evidence came in. So this is the time where all the evidence is in, and now we attorneys get a chance to talk to you about that evidence. What is the evidence? We'll start with Exhibit 1. This is about Jennifer Dazey and her dog Echo. Ms. Lassance introduced you to them at the beginning of this case. You heard about her health issues. She had brain tumors. She had a surgery to remove those. She was recovering, moving forward in life. That all changed as a result of a particularly brutal and heinous act on January 18th of this year, which ended their lives. This is the front of 1605 Avoca, where Jennifer Dazey resided. On January 18th, her friend Christy Folman came by for planned coffee. They wanted to get together. Ms. Folman had been dealing with her own health issues. In fact, both of them had been in the hospital at the same time for their various health issues. They were just kind of getting back in touch, getting back together. They planned a coffee to sit down and catch up on things. Ms. Folman arrived. She noticed right away that there was a truck in the driveway and Jennifer's car was gone. That's Jennifer's son's Nick's truck. She didn't think much of it because vehicles got traded periodically there, and it was no big deal. Next. She walked up to the house. She went into the porch. This would be the front door that she got to. It would be coming in the front porch. She'd be right there at the front door of the porch leading into the house. She proceeded to open the door to go into the living room, and that would be what she saw. She opened the door. You can see into the dining room area. You can see the pillar in there that was talked about. It's pillars that separate the living room and the dining room. So she was looking right in through there when she saw Tyler Dazey between the pillars, facing away, and he was naked. She stood up and said, this is what she saw standing there. She was surprised and somewhat embarrassed when she saw that, so she started backing out of the door again. Then she heard some footfalls, and she heard a door close. She thought, all right, it's safe to enter the house. She goes on in, like she always did. Next. That's one too many. Oh, must have missed one. Anyway, she put her coffee down on the table. She took off her shoes, put on socks. That's when she saw the dog Echo on the couch under a blanket. She went over and picked up a leg of Echo and let it go, and it dropped. Now she began getting puzzled. She went to the kitchen. She looked, and she saw that the door to the basement was closed, that she knew that Jennifer was not in the basement because anytime she went down there, she left that door open. She tried calling and she tried texting. When she came out of the kitchen, this is back in here, she looked over and saw right here a little nightstand sort of affair which had Jennifer's purse on it. She knew that Jennifer never left the house without the purse. So now she was getting confused. She went to Jennifer's bedroom. The door was closed. That's an important point. So she went in the hallway, went down to Jennifer's bedroom. When she went in there, she called out softly. The blinds were drawn. It was dark. She was trying to wake Jennifer up. Hey, why are you still in bed? She could tell that Jennifer was in the bed, but she couldn't see any details. She moved closer, tried to wake Jennifer with a low voice. That's when she saw this. She closed the door, braced it with her feet, back to the door, feet on a dresser, called her boyfriend right away and said, I think Jennifer is dead, get over here. Then she called 911 immediately, got on the phone. You heard the 911 call. I mean, that was sheer terror. That's the only way to describe that. You heard Officer Hesselbecker was dispatched, and he arrived at the scene shortly thereafter. Ms. Fulman was on the 911 call, heard the officer enter the house, and she went to him and said, don't leave me. But the officer has a duty to do. He had to go investigate. So he said, go, and she went back into the kitchen, and she was hiding out back here near the pantry or mudroom or whatever they were calling it at the time. Officer Hesselbecker entered the room with his flashlight, turned on the light. That's the scene that he saw. You got to see that with the body cam that he was wearing. You saw the whole thing. You can look at it again if you want. You'll have that. We don't need to dwell on it here. You saw what he called in and reported a homicide, and the cavalry started rolling. People started showing up. Lieutenant DeJuste arrived, assisted in clearing the house room by room. He announced numerous times, police department, make yourself known. Numerous times. There was no response. They cleared the basement. They cleared the main floor. Eventually, they got to the room, the back bedroom that Tyler Dazey was in. Officer Slide and DeJuste cleared the room. You saw that on the body camera. They found Tyler Dazey face down naked. They thought it was a body at first. Then Officer DeJuste said he's breathing. They decided that they wanted to secure him under these circumstances. Mr. Dazey complied with instructions and directions. He stated his right wrist hurt. There were no bloody clothes found anywhere in that room. Then Mr. Dazey was ultimately placed in a Tyvek suit. That was to preserve evidence and just to cover him. Investigator Rosenthal noted at the time that Mr. Dazey had abrasions on the back of his right hand and the back of his fingers on his right hand. He was taken to Mercy Hospital to be cleared. He followed instructions up there. Officers obtained search warrants for blood and urine to check for drugs and to look for possible influence of drugs. While they were waiting there, Mr. Dazey stated that he needed to urinate. He was asked to hold it briefly so a sample could be collected. Mr. Dazey stated, "I'm letting go now, the keys are yours," and urinated in the Tyvek suit. When Investigator Rosenthal told him that he could have held it a little longer, Mr. Dazey responded, "Wars are meant to be fought." He urinated in the suit several more times, and eventually at the law enforcement center, he said he needed to urinate again. Officer Rosenthal said, "You don't need to do it in the suit again." He grabbed a collection cup, held it in place to get a sample. Mr. Dazey then said it might take a while and that he didn't want to dick you around. Then he said, quantum entanglement, brother," urinated all over Investigator Rosenthal's hand. Samples were collected in that incident. They were sent to the crime lab along with blood samples. The lab results showed that Mr. Dazey had ingested THC isomers of different types, which would be that contained in the gummies, the vapes, and probably from actual marijuana plants. These are these various modifications made to the THC. What they did not find was PCP, fentanyl, opiates, or any of the other hard drugs, so he was not under the influence of any of those things. Now, while all that was playing out at the hospital and the law enforcement center, investigators were working on the scene. Blood spots were found in the hallway outside Jennifer's bedroom, which would be in here, and they were also found in the dining room, living room area going over to where the dog was found on the sofa. A hatchet was found on a shelf in the bathroom, and there was a sheath to that was found on the dining room table. Both of those items are in evidence, and you can see that the sheath matches the hatchet. The hatchet also says SOG on one side, which is the same brand as the sheath. The Ring camera was checked and showed several things. One, it showed the switching of the vehicles at around 8 p.m. the night before, where Jennifer's son Nicholas came, dropped off his truck, and took her car. Something wrong with his truck. That would have been the evening of the 17th. Jennifer let the dog out and in at about 10 p.m. that night. Nothing happens on that Ring camera until the following morning at 8:38 when Ms. Fulman arrived at the house. Officer Hesselbecker arrived at 8:51, and you saw all those video clips, people coming and going at the front door of that residence. Nobody else went in or out that front door. It was not on the camera. It's motion activated. There was nobody else in or out. Exhibit 24 shows the back door to the house with the deadbolt vertical. The testimony was that the owner was contacted when I don't know what you call the thing, a thumb something or other, when it's vertical, the deadbolt is locked. That was locked when officers got there. There was no evidence of forced entry. You had officers on the perimeter when they got there. One of their functions is to check windows and doors and look for forced entry. They checked that on the interior. There's no evidence of forced entry. Tyler Dazey was the only living being in that house on the morning of January 18th. He told Investigator Rosenthal that he owned a hatchet, which he last saw in his toolbox that morning. He also told Investigator Rosenthal that that he had just taken a shower that morning right before officers arrived. The hatchet was sent to the lab. Technicians could not state definitely if it had been cleansed or scrubbed. However, there was blood stains on the hatchet, on the head, the blade, and the handle. They didn't find actual blood, but they found the stains. So the question would be, how do you get stains on there unless at some point there was in fact blood on there? The blood residue, or the stains, was swabbed, and they found that DNA of Jennifer Dazey on the handle of this hatchet. There's marks on there. The DNA lab person said they're marked and they're numbered. That's where they pulled the samples from. They're little circles marked with some kind of a marker. Obviously, the hatchet was scrubbed in the shower. There had to have been blood on there to get blood residue or blood stains, and there was enough on the handle to get DNA from it. Not enough on the blade, even though they tried. Further, the handle of this hatchet had a right palm print on it. And they lifted that palm print and they checked it with known palm prints, and that belonged to Tyler Dazey. The lab tech couldn't say with certainty that the hatchet was scrubbed, but said the prints showed signs of either a wet hatchet or a wet hand when the print was left on the handle. Again, that was scrubbed in the shower. It came out, it was wet, the hand was wet. That's why we got the print on there, and that's why the tech saw that there was water involved when that print was put on the handle. Echo the dog was taken up to the veterinarian for examination. Dr. White determined the cause of death was sharp force trauma penetrating the skull. Maybe it was blunt force trauma, which was consistent with the spike on the hatchet, on the back of this hatchet, the spike being driven through the skull and into the brain cavity of the dog. Dr. Cruz, the medical examiner, performed an autopsy of Jennifer Dazey. She determined the cause of death was sharp force injuries to the head, face, and neck. There were 17 injuries, 13 of them to the face, head, and neck. There were 2 fingers amputated or nearly amputated. You saw those photographs. You saw, the autopsy photos. You'll have them again if you want to look at them further. They'll be with you. The fatal wounds penetrated Jennifer Dazey's skull and penetrated the brain, some 1 and 5 inches in depth on the forehead. The neck injury was 2 inches deep, went all the way to the vertebrae. There was damage to the vertebrae, but it didn't get to the actual spinal cord. The doctor also said these wounds are consistent with this hatchet striking Jennifer Dazey in the face and the head, given the width of the blade and the wounds that she observed. One of Jennifer Dazey's fingers was amputated completely and was found on the nightstand. Another was hanging by a piece of skin. There was another cutting wound near the thumb on that hand. The amputated finger was either severed with great force and ended up landing on the nightstand, or it was placed there, but it ended up over on the nightstand. The severed fingers are also consistent with blows from this hatchet. And if you look at the blade on that, the narrowness of this blade, and you look at a hand, you can see how this hatchet could have come down, taken those fingers off, and not affected the small finger and the index finger. If it were a large wood-cutting hatchet, probably would have got all 4. But this particular hatchet, very consistent with those fingers and leaving the other two unscathed. It's clear from the evidence that this hatchet is the instrument of death for both Jennifer Dazey and Echo the dog. It's equally clear from the evidence that Tyler Dazey was the person wielding this hatchet. His palm print was on it, the DNA matches up, and he was the only one there, nobody else in or out of the house. He told Officer Rosenthal that he only slept about an hour the night before. He was in his room all night contemplating this attack. He took the hatchet from his toolbox. Naked, he went to the dining room where he removed the sheath and left it on the table. Then he proceeded to Jennifer's bedroom where he swung that hatchet 17 times, striking her in the face and head. She put up her hand at some point in defense. The hatchet came down, fingers came off. Given Mr. Dazey's statement, he's probably talking at the time this happened, calling her a whore or a witch before or during the attack. He left the bedroom. He was dripping blood in the hallway and the dining room, blood spots, when he came out and made his way to administer the fatal blow to the dog on the couch. Then he went to the bathroom, showered off the blood spatters. There was blood spatters on the wall, blood spatters on the jewelry box, blood all over everywhere. There had to have been a lot of blood over there with these 17 blows with this hatchet, including all over him. So he went to the bathroom and cleaned up. While in the shower, he cleaned the hatchet, cleaned the blood off, but he didn't get enough because the residue remained, the staining remained, and that's how we got Jennifer's DNA off of the hatchet. That was used to kill her. Left the palm print when he placed it on the shelf. He killed his mother with the hatchet. There can be little doubt of that. Now, let's take a look at your instructions. I'm not going to throw them up on the board and go through them. The judge has already read them. You're going to have them, but I do have to touch on some of them. The big one, is instruction 15 for murder in the first degree. Element number 1 is on or about January 18th, defendant struck Jennifer Dazey with a dangerous weapon. You have to go to the instruction number 20, which defines dangerous weapon: any device or instrument designed primarily for use in inflicting death or injury, or any instrument actually used or intended to inflict injury or death. This hatchet, particularly, is designed as a killing instrument. It's got the big spike on the back. It's got SOG on it. In Army parlance, that's Special Operations Group. I'm sure the manufacturer is selling it to people as some kind of a battle hatchet. This is not a wood chopping hatchet. It's pretty obvious. It's got this big medieval looking spike on the back of it. But even if you believe that this is a wood chopping hatchet, then you have to look at it as an instrument used to inflict death. This is like a baseball bat. It's a baseball bat when used to play baseball. If you use it to bash into somebody's head, it becomes a dangerous weapon. So even if you think this is an innocent camping hatchet, it was used in such a way to make it a dangerous weapon, and it is, in fact, a dangerous weapon. Element number 2, Jennifer Dazey died as a result of being struck with the dangerous weapon. The medical examiner answered that. The cause of death was multiple sharp force injuries consistent with blows from this hatchet. Element 3, that Mr. Dazey acted with malice aforethought. You have to go to instruction number 16 for a definition of malice and malice aforethought. So that says malice is a state of mind that leads one to intentionally do a wrongful act to injury of another out of actual hatred or with an evil or unlawful purpose. So actual hatred. Mr. Dazey stated to investigator Rosenthal that his mother was a witch who put evil on him. He said he doesn't need her to validate him and asked why would he care what a whore thinks. He said, you want to sit and drink yourself stupid, fuck like animals, and ruin your children's lives. Why would I care what a person like that thinks? He called his mother a whore often, said, you know how witches are. I'm better than you. I'm going to be your fear. I'm going to be your enemy. He explains his mother's injuries when asked as witchcraft. There's clearly hatred in those statements, but there's also the evil option or alternative. And I'll just simply state that 17 blows with this hatchet to someone's face, head, and neck is evil. And if it's not evil, evil doesn't exist. This was also a deliberated act, not in the heat of passion. You might be able to stretch it and say it was a heat of passion with one blow, but there were 17 of them. That's not the heat of passion. The time Mr. Dazey decided to pick up that hatchet and unsheath it and then go to Jennifer's room was when he decided to do what he was going to do. There's no limit required. There was malice aforethought before each blow, 17 times. He had fixed purpose and intent 17 times. He thought about this before he even took that hatchet out of the toolbox. That's premeditation. That's intent. He knew exactly what he was going to do. Also, you look at instruction number 19. In this one was used with malice, premeditation, and specific intent to kill. And malice aforethought is in another instruction, but the weapon itself allows you to make that inference. So the third element is satisfied. Element number 4 is that defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill. We just covered some of that. Instruction 17 defines willful, deliberate, and premeditate. It's not accidental. 17 blows is not an accident. That's thinking about it 17 times. To deliberate is to weigh in one's mind, consider, contemplate, reflect. All occurred before he took that hatchet out of the toolbox, picked it up, took the sheath off, and went to do what he did. To premeditate is to think or ponder. Premeditation began at the beginning and followed all the way through after the murder of Jennifer Dazey to the killing of the dog. That shows premeditation because it didn't end with Jennifer Dazey's death. It continued on the whole plan to the dog. That's premeditation. It was the whole plan. Deliberation and premeditation need not exist for any length of time. You don't have to ponder this for days or weeks or months ahead of time. This can happen instantaneously before the act. As long as you ponder it and as long as you deliberate, that is premeditation. You go back to instruction 19, again, the inference. You may infer that the weapon was used with malice, premeditation, and specific intent to kill when a dangerous weapon was used and death results. Make that inference. Make it. Now, you've seen all the evidence, all the crime scene, autopsy photos, findings of the medical examiner, the veterinarian, all the lab people came in. There was a lot of evidence you heard. You've heard from police officers regarding their investigation. You've been instructed by the court with the law as to what the law is. You need to apply those instructions to the evidence. Tyler Dazey took this hatchet, dangerous weapon, with malice aforethought, premeditation, and specific intent to kill. He willfully administered 17 blows to Jennifer Dazey's head, face, and neck, killing her with this. Use common sense, use observations, use your experience, think it through, and find Tyler Dazey guilty of first-degree murder and animal abuse. Thank you.
Mr. Blair, whenever you're ready. Is it turned on? Test it. I don't know which number you have. He had one. I have two turned on.
What does it say on it? Got me now.
You're on.
I'm gonna set it down here. Hopefully everybody can hear me. May it please the court.
Counsel.
Counsel? Thank you. Could you actually, and I'll tell you, we'll want ours in a second.
I've got it on yours.
All right, but we don't actually want it up there yet.
Yep.
Just gonna have this in front of me, I guess. I'm gonna move that stuff over there. Okay. Starting off, first thing I need to say is thank you. Mr. Nelson already said it, I'll say it too. We talked about it a little bit during voir dire. Mentioned the fact that they wanted to serve on the jury because, among other things, it is their civic duty. I want to say thanks. This system doesn't work without it. I believe in the system. I have to believe in the system. We talked a little bit about what's different in our system and else's. I think that the way our system works. And we have an impartial trier of fact, and that requires you. And so I say thank you. I'm going to do what Mr. Nelson. All right. I'm not going to walk through the case step by step. To read to you from the jury instructions. I will talk briefly, very briefly, about one jury instruction. And I'm going to try to keep this relatively short and to the point. I only get to talk to you once. Mr. Nelson gets to talk to you twice. And after me. And that's because he has the burden of proof. And we talked during voir dire a little bit about that burden, what that means, what that burden of proof is. All right? And you've got the instructions, and you saw them. Right? You can read how it works. Somebody, I forget who it was, right away when I questioned during voir dire, piped up right away and said, when I asked, what does the defense have to prove? He said, nothing. That should be clearer now than it ever has been. Instructions. I say that because of one particular instruction. You look at jury instruction number 10, it talks about the burden of proof and guilty beyond reasonable doubt and all of that. The only place this occurs in the jury instructions. And this is by design. In the second paragraph of that instruction, it says, A reasonable doubt is one that fairly and naturally arises from the evidence in the case, or from the lack or failure of evidence produced by the state. And yeah, I put emphasis on that. And then down in the last paragraph, it says, if after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state. It's the only jury where they do that. Themselves. Because that's the crux. They're trying to make sure you understand who has the burden of proof and what. It isn't just about having presented some evidence, as that evidence probably happened. Okay? It's about, did they plug all the holes? Did they give you the puzzle? Did they give you half of the puzzle pieces? Remember, as you look at the evidence, and you're going to have the chance to take all of this stuff back with you, all right? It's not committed the crime or how terrible the crime is. We all, states, those pictures that they show them to you, a real reason. Of the crime, not the facts of the case. They want you to engage in emotions and not. What it's really about whether or not the state has proven beyond a reasonable doubt the defendant is the one who killed Jennifer Dazey. That's what the case is. Remember Mr. Hoover's opening statement? I'm going to talk. We're done. You're going to understand what we're. Okay. Everybody does this. I understand that. Unfortunately, sometimes law take the path of least resistance. Sometimes they take the easy way out. Sometimes, every now and then, you've heard the phrase, round up the usual. And it hasn't just survived from the movie. One of the ways in which take the easy way out. They take the path of least resistance. It's how it's done, unfortunately. I'm going to talk about certain items of evidence. You can see this pattern. You can see how this happened. For example, the first items of evidence we see in the case, we heard from Christy Folman, and we heard from Officer Hasselbecker. Okay? We also saw the ring cam video and Officer Hasselbecker's body camera video. And when I forget if he had one on when he came in here, but we got to see the body camera footage. And in all of that footage, one of the first things we see is Nick Frey's truck sitting in the driveway. All right. And Christy Folman and Officer Hasselbecker both told us about that they saw that as well. Christy Folman told us that the GMC is not at the house. All right. Now, we know from Investigator Hoff's testimony that Jennifer Dazey was in Acadia and filled up the gas tank in the GMC for station, because he went. With the interview with Nick Frey from the officers, Nick drops off the Acadia, evening of the 17th. All right. Of the officers reporting what they heard, I think it was Investigator Crable, reporting what he heard from Nick Frey, was that Mr. Frey had then driven, at some point, drives out of Dubuque towards Cedar Rapids. And a big deal of the fact that they followed him on the cameras as he drove out of Dubuque towards Cedar Rapids. Did you notice what they did? They didn't ever confirm where he went in Cedar Rapids or that he ever arrived. They didn't continue to watch the cameras when he came back. Whether or not he immediately turned around and drove back. Is it that long? Interesting things about that whole scenario. To see a couple of clips of the ring camera footage. We were told that Nick stopped at the house and that there was ring camera footage from the front door of Nick exchanging vehicles. Did we? We were told about it. Does that seem like something that we should have seen? After he goes to Cedar Rapids, or in the direction of Cedar Rapids, go the places that he said that he was going to go, things that he said he was going to do? Or did he turn around and come right back? That seems like it's very similar. In their closing argument, the state just said Tyler Dazey is left or right-handed. But we don't have that evidence, do we? It's not in evidence. It's not there. Officers talked to lots of people, including his brother and sister, according to Investigator Crable, who would know the answer to that question. This is another item of evidence that's of significance. We talked a lot about the back door. All right? Christy Folman that back door was pretty much never used. All right? But if you look, and Chad Stair, I'm sorry, I may have his first name wrong. In any event, Corporal Stair told us that those steps have clearly been walked on. And 2 investigators told us that it had just snowed quite a bit with several days. You can see the Ring camera there in that picture, up in the corner of the door. You saw other closer pictures. I'm not going to page around and show you that. What I would note to you is a couple of things. The door is locked. But that didn't lock the door when they left out the door. All that requires is a key. Now, that leads to some interesting word. The last thing we knew, and this would have been at the time Kylie moved out, but the only keys were in the possession of Kylie and Jennifer. And then we heard from Investigator Hoff, when he's investigating at the time of the incident, that there is a dispute because Kylie has never returned the back door key. Did anyone ask Kylie about the back door key? Did anybody get the back door key from her? Does that seem like something that we know? And if you think about it, I believe it was Investigator Hoff testified that at some point later in the case, he actually gets a key. Did you receive, investigate? I forget what the exact question was. Investigators talked about, and they showed us, there's actually a close-up picture in the evidence, and you can look at it, of that camera. It's a, right? Same brand, same, not the same type of camera, but the same system as the one on the front door. Investigators told you that they were able to get footage from the one on the front, but that they could not get any footage from the one on the back door. Now, the subpoena that they served on January 1st, January 19th, which not only would have covered the date of the incident, but it also would have covered the time that the officers were out there taking this. Should have been footage. Investigator Hoff tried to tell you, he got up there for direct examination, and he tried 3 ways that could happen. Either the camera was broken, somebody hadn't paid for that camera's footage to be saved, or nobody went, that there was nothing, since it's motion activated, there was nothing that triggered the motion sensor. On cross-examination, you will remember the judge was nice and allowed me to ask, I think, the first 4 questions of cross-examination. We kind of one attorney, one witness kind of thing. You probably noticed that as we went through it, but that was the one exception. I was allowed to ask 4 questions, and then Mr. Hoover took over the rest of the cross-examination. And what I asked him about was the Ring camera app. And he acknowledged that what he didn't tell you on direct examination was you can go into the Ring, you have access, change. Had access to those Ring cameras. Isn't that something that we should know? He talked about one of the examples I used was, I used one from my own life, and I asked him about it, but, you know, could I have the Ring camera app on my phone, and my wife would have it, and my daughter would have it? Which is, in fact, the situation. And he said, yes, if I share it with them, they would all have it. It would require me to share it with them, but then they would also have access to that app, and any of us could turn off that camera. Interestingly, because about finding her phone, all right, did anyone even check Jennifer's Ring app on her phone to determine whether or not it indicated that the camera had been turned off? Whether it was functioning, whether it was recording. Did anybody even check? Be nice to know that, wouldn't it? Another example in the evidence was the DNA print. Remember about my neighbor who wanted to sniff and feel my grass? And one of the pieces of evidence that we talked about at that time was my neighbor's ID that was found. The question was whether or not, what was the significance, kinda. I asked, does it make a difference if fingerprints are on the ID? Does it make a difference if my neighbor's kind of correctly pointed out, well, no, it's the neighbor's ID. You'd expect to find their DNA and their fingerprints on it, right? In that little, you got to see, and you figured out, the limitations of DNA and fingerprint evidence. All excited about DNA and all sorts of scientific, most of which is either completely fictional, in actual application. Predicted or it is working. What we see in our case, we got to see the limitations on that type of evidence in great detail. We also got to see the way in which the necessary and fill those gaps. Do you remember item 7, first, the DNA report? That was the blood drop the floor in the living room, the one that was down near the couch. I think 4 in the picture. You can go back and look at those pictures. But what was interesting about it, during off, told us that it was sent expert, and they got the report back, and that was Jennifer Dazey's blood. Remember that? And then, when they got up there, on direct examination, mistake. I don't think she meant to say it. Okay? But my memory at least is, and maybe you caught it, she actually went so far as to say, in referring to item number 7, that was Jennifer Dazey's blood. And so you probably noticed on cross-examination, I got a little ridiculous with her. I went go way out there. He couldn't say DNA. They didn't test for that. Is there determine whether it was human or animal? They didn't test for that. And it might have seemed a little silly at the time. But remember they swabbed Tyler Dazey's nose? And it tested positive. But I made her say he couldn't tell you that the DNA, that Tyler Dazey's DNA, blood, or that was Tyler Dazey's blood. She couldn't even say that was Tyler Dazey's blood. Why is that important? They didn't test for that. Any of the blood, any of the DNA. They didn't test for it. Does that seem like something we ought to know? We went through every item of evidence with the DNA expert. We talked about each of those items. Whether or not the DNA comes from the blood. You developed a DNA profile. Did it come from the blood or did it come from other sources of DNA? No, I cannot. Can you tell me, one exception, can you tell me whether or not the blood came from a human or an animal? Could have performed that testing. You tell me whether I already said, but no. Yeah. Can you tell me whose blood that is? No. Can't tell you that. Didn't do that testing. Wanting. Didn't do that testing. Don't know that answer. And it really made for some interesting, if you look at the DNA evidence, it really made for some interesting, because it gave you their theory of the case. And they put Tyler Dazey in the shower washing off Jennifer Dazey's blood. In their version. Did you get that? And they swabbed the tub in the shower. Really quite interesting was the one they did. positive, the tub drain tested positive for blood, don't know if it's human or animal, did not find Jennifer Dazey's DNA. It wasn't there. But supposedly, DNA expert told me that blood is an excellent source of DNA. And it's not there. Oddly, the blade doesn't test positive for any blood. There's no DNA found on the blade of that hatchet. And apparently, there was no testing done to determine if the hatchet had been cleaned. We also had a fingerprint expert. That was some testimony. State called a fingerprint expert to tell you palm print, hatchet, belonged to Tyler Dazey. Remember the driver's license that belonged to my neighbor? I don't know that it's terribly significant that Tyler Dazey's palm print is on a hatchet belonging to Tyler Dazey. Is it significant that also on that hatchet at some point is Jennifer Dazey's DNA? I don't know. Know if Jennifer uses that hatchet. Certainly an object that's in her house where she's been living. But our DNA expert told us that it would not be unusual for somebody's DNA to be on objects or in they use or frequent. It's called touch DNA. You leave DNA when you touch things. It's your cells. It's the oil in your hand. It's all that fun stuff. Breath when I exhale, which I admit was true. The expert did talk about signs of moisture in the print, but she admitted that that could be due to any number of possible causes, including sweat. One other thing she talked about really hasn't talked to you about, and they may attempt to now, but I'm sure they'd like to stay away from it, is the smudges in that palm print. Because the state's fingerprint expert admitted on cross-examination that caused by some using that hatchet after the print had been left. Basically, you leave a print on something, and then somebody else touches that. And the spot where they touch it is then smudged, or could be smudged. I believe one of the things she said was, especially if that person was wearing gloves. Investigator Rosenthal told us about the arrest of Tyler to the hospital and the subsequent attempt to interview him. You remember all that? He talked about Tyler's odd behavior. It was actually odd enough that instead of taking him to the law enforcement center for an interview, they actually, all right. Small town. There talks about common sense. And one of the things that I was taught regarding speak louder than words. What is the fact that they took him to the hospital first? What is that saying to you? Did you catch the part where one or more staff up at the hospital in the behavioral health unit of the emergency room, as they were talking about it, was familiar with Tyler? That came out in Investigator Rosenthal's testimony on direct examination. The state elicited that. It was right there. Investigator talked about some of the things that happened up at the hospital and tried to imply that Tyler was just being difficult or obstructionist. Investigator Rosenthal also told you about his attempt enforcement center. Remember that? He told you about some of the things. And on cross-examination, we talked about a few more of the things that were said. But you making a lot of sense. Investigator Rosenthal tried to make a big deal about Tyler's alleged last conversation with his mother. But as we brought out on cross-examination, Tyler didn't answer him. He talked real person conversation, or was he talking about a conversation that they were supposedly telepathic as they exercise entanglement and no. He actually talked at that point about his mother practicing witchcraft upon him. So was Tyler actually talking to me at a, or was he talking entanglement or whatever? Investigator Rosenthal also talked about Tyler. They had gotten out of the car thing and had the floor and pick it up before they got Tyler out of the car. And he said he went back, he watched that video, a video we never got to watch, by the way. Wouldn't that have been nice?
John, I'm going to object. Talking about things that are not in evidence.
That's true. Keep your comments to what the evidence was.
Approach?
Yes.
Thing about that told us about is that he told us about a conversation that was happening between Tyler and his dead mother, who was a mental conversation. It was the conversation that took place in the back of the squad car when Tyler was the only one in the squad car. Investigator Rosenthal also tried to emphasize Tyler telling him Tyler had seen the hatchet that morning. But according to Investigator Rosenthal's testimony, Tyler didn't tell him where he saw the hatchet, only that he'd seen the hatchet. Well, investigator picture that the state just of the hatchet, found it on the shelf above the toilet. And Tyler told investigator Rosenthal that he had showered the night before and sometime that morning. Did he see the hatchet at some point in the bathroom? We don't know. I'm not going to talk about everything that was said during the attempted interview of Tyler Dazey. I'm simply going to remind you that Investigator Rosenthal told you that the whole interview was recorded. And I'll leave it at that. Do you remember Investigator Rosenthal's testimony? He told you about how he tracked her on the traffic cameras around her Life 360 app. Remember that? Remember we talked early on in opening, we talked again, a little bit of least resistance, about taking the easy way out. He watched after she dropped off at, I think, 10:30, until the next morning when she goes back to work, she comes out of her house and she gets a cab. In any event, all night. It was impressive. Get to the part where, from the camera he was watching, as he admitted, he couldn't see any of the entrances or exits to that residence. And he told you that there were thousands of cameras downtown. Right? Actually, that there were over 1,000 cameras in the was his exact testimony. And they did no testimony that he did any. She left her residence at any time overnight. As he admitted on cross-examination, only track the person. And remember, as they told us, there are no cameras on Avoca. Investigator Crable's testimony he talked about the interview with Kylie, and you got to watch a portion of that interview. And he told you, everyone deals with grief differently. But did her demeanor and attitude, the giggling and laughing, did that strike you as odd? Now the investigator in this situation will deal. I would suggest to you that this is a perfect example of what we're talking about, of taking the easy way, the path of least resistance. Because if Tyler wasn't, I wouldn't be the one talking to you about that video. They would be. Because Kylie is the next path of least resistance. She's the next usual suspect. And if because Nick is the next usual suspect. I can't prove that Kylie killed Jennifer Dazey beyond a reasonable doubt based upon the limited evidence that we have here. My point is that the state really hasn't ruled it out as a possibility. They basically pretended to do it. That for your benefit, but they didn't actually do that. It was just a show. The same can be said for Nick. I can't prove Frey killed Jennifer Dazey under reasonable doubt, not based upon the evidence that we have, not based upon the evidence that's been presented by the state in this case. Likewise, it proved that Tyler Dazey killed Jennifer Dazey. Not based upon evidence presented in this case, not based upon what's come in during this trial. They did. Just did a murder. Presented. During that, you heard about lots of things that could but weren't. Usual suspects. Supported the conclusions, and then they tried. That conclusion was the first 5 minutes of the investigation when they entered Dazey's bedroom, possibly even before that. They avoided questions, even some didn't actually support those conclusions. This isn't a. This is 4 pieces puzzle, and they want you to say not only that it's a cow, kind of cow, and what gender. Still missing 5 or 6 pieces with all the crucial information. Ladies and gentlemen, any of these alleged crimes. Please look at the evidence. Pay particular attention to what is missing. And then return a verdict of not guilty.
Mr. Nelson, whenever you're ready.
First of all, there's an instruction that you need to look in there in that packet that says what we as attorneys say is not evidence. I gave you a whole lot of evidence when I was up here talking. Mr. Blair Gave you a big old mud ball against the wall. He's hoping something sticks. This was basically obfuscation. That's throw a whole bunch of static into this and try to picture something that it's not. He complains that it's everybody else's fault except Tyler Dazey's. First of all, inadequate police investigation. You all sat here, you heard from the investigators. There was an extensive investigation done on this case, and everything points to Tyler Dazey. Now, the next claim is somebody else did it. Oh, it was Nick or Kylie. Well, why aren't there palm prints on this hatchet? Pretty clear, this is the instrument that caused the death. Tyler's palm print is on the handle of that instrument. We heard evidence from experts, not from attorneys, experts that said how those palm prints can be on there, that there was water involved, either on the hand or on the handle. That's not Nick's or Kylie's handprint on there. The Ring camera was another thing. Who controlled that? Well, there was no code found for the phone. Nobody can look into Jennifer's phone to find out what was going on with that. It doesn't exist. It wasn't evidence. Again. Well,
the objection's noted. Go ahead, counsel.
You have to remember, use your notes, use your own memory as to what was or was not in evidence. That's something that was not available, according to my memory. The Ring was contacted. They got evidence from them that said that there was no activity on that particular camera. There's all kinds of reasons why that would be. Maybe it wasn't paid for. Ring did not give that up. You have to pay an extra, $50 a month, I think was what was talked about. There's a lot of people have those cameras, decide it's not worth paying that kind of money, take it off. The lab tech, DNA, a lot of hay was made about, well, she doesn't test for blood. She tests for DNA. On occasion, she's going to test for blood, but in this particular case, she's swabbing. There was blood found on another test. She swabbed the stain, and on one of those stains on the handle, she was able to pull the DNA out of there. Okay, she doesn't go test whether it's animal blood or whether it's people blood, and during the course of that exchange, I asked the question, would you expect to find Jennifer Dazey's DNA in a drop of animal blood? Obviously not. We don't have to be experts to understand that. Experts talk in a whole different language than we do. When they say, I can't conclusively say that, what they can say is, well, I'm 99.9% sure, but I can't be absolutely conclusive. That's how they talk. Well, we can turn around and say here that, well, she can't be absolutely certain. Well, you see the difference. What the lab tech said was the DNA was found on the hatchet, and it was swabbed from a blood stain. How could there be a blood stain on the hatchet if there had not been blood on the hatchet? Now, to talk about where it went, well, we're speculating more of the mud ball, hoping something sticks. I think we talked earlier about the video stuff. And I asked you early on, I said, some people are of the opinion in this day and age that if it's not on video, it didn't happen. Mr. Blair is pushing real hard for that. He wants you to believe that, well, if it wasn't on video, it didn't happen. This is a case where you're not going to have all kinds of video evidence. It's not available. This is old school. We have to go by all the evidence. You have to use common sense when you go through it. It's circumstantial evidence, and it all leads back to Tyler Dazey. Now, one of the big defenses in this case is Kylie did it. Well, Kylie lives across town. In order for her to do this, she'd have to slip away from her house. I mean, Investigator Rosenthal spent days going through traffic cameras, tracking her movements around town in order to eliminate her as a suspect. Days he spent digging through this stuff. In order for her to participate in this, to be part of this, she would have had to leave her house at the other end of town somewhere during the course of the night, through the back door, get out of a nice warm bed and get out into that cold air, and then sneak around through the alleys and through yards, and then get a hold of an Uber or a cab, because she didn't have a driver's license and she didn't have a car. How was she going to get across town? Okay, she'd have to go through all that, get over to Avoca Street. She couldn't get dropped off right out front, so she'd have to be dropped off blocks away perhaps, and then work her way over there. There were no tracks in the backyard, you know, human tracks. She would have had to go up the driveway where she could have been seen, and then she would have had to enter the back door with a key that she may or may not have had, and then she would have had to go in, get a hold of her mom's phone or some phone, disable the camera, erase all the footage that was on that camera, and then go in there and sneak in to Tyler's bedroom, get the axe, the hatchet, out of his toolbox without waking him. And remember, Tyler said that he only slept about an hour the night before, an hour. So she would have to time that to get in there when he was sleeping during that 1 hour and get the hatchet out of the toolbox and take it out. She would have had to strip herself naked because there was going to be a lot of blood, and go in and commit this act and also kill the dog, and then go in and clean herself up, put the hatchet up there in the shower, go get dressed. Then she'd have to sneak back into Tyler's room, lift up his right hand, and get his palm print on the hatchet so she could put it back in the bathroom where it was found. Now, Tyler also said he last saw the hatchet that morning before police arrived. How could he see it that morning in his toolbox when it was actually over in the bathroom? You know, it was a nice try. Let's throw this whole story together, but it doesn't fit. What we got here is a whole lot of evidence that got presented, a lot of evidence. It all goes right to Tyler Dazey, all of it. We're not here to eliminate everybody in the state or everybody in the country. That's not the function of law enforcement or my office. We're here to gather the evidence, and we're here to prove that Tyler Dazey committed this crime. We have done that. We have presented all kinds of evidence, scientific evidence, investigative evidence, physical evidence. It's pretty clear what happened here. Circumstantial evidence. Tyler Dazey was the only living being in that house. The only one there. Nobody else. Nobody came in the back door. Nobody was sneaking around through the night. It's just not there. Look at this evidence for what it is. Circumstantial evidence. It takes us right to where we have to be. Mr. Blair says this is not about milk cows. It is, folks. All the evidence is there. There might be one or two little pieces missing, but when you look at it, that milk cow is right there, plain to see for everybody. Tyler Dazey committed this act. It was a heinous act. There's no other way that anybody else could have done it. It was him. The evidence points to him. It confirms it. Find him guilty of murder in the first degree and animal abuse. Thank you.
Okay, if you folks want to turn your instructions back to number 33, we'll read the last four. Instruction number 33. During the trial, you've been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. Instruction number 34. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website such as Facebook, YouTube, Snapchat, Instagram, or Twitter, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Your cell phones must be turned off during deliberations. If the length of deliberation causes you to need to make a call regarding personal arrangements, such as childcare or other scheduling issues, you may make such calls when the jury takes a break and temporarily stops deliberations, but you must not discuss the case until after you have reached your verdict and I have released you from jury duty. Instruction number 35. When you begin your deliberations, you should select a foreman or forewoman. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong, but do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are judges of the facts. Your sole duty is to find the truth and do justice. Instruction number 36. I am giving you one verdict form. You will find only one verdict on each count. When you have agreed upon a unanimous verdict and the foreperson has signed the verdict form, please notify the court attendant. This case is submitted to you this 19th day of July, 2024. Okay, just a few additional pieces of information, and then we will send you out for lunch and deliberations. First of all, we've indicated to you that the exhibits will be available to you. They will go back with you to the jury room for you to examine and look at. Make sure you don't alter, change, destroy them in any way. They need to come back to us in the same condition. All exhibits other than the hatchet will go back with you. If you want to see the hatchet, let the court attendant know that. In that case, one of the deputies will come back into the jury room to let you observe the hatchet. Please understand, while the deputy's in there, there shouldn't be discussion or deliberation about the case. You can look at the hatchet all you want, spend as much time as you need. When you're finished, tell the deputy thank you. He will leave again with the hatchet, and then you can start discussing the case. We do that because no one should know what your deliberations are and what you're discussing about this case, even the deputy who brings in a piece of evidence. I indicated to you about your phones. When you start deliberations, the court attendant will keep your cell phones. If you need to use your phone at some point in time, let the court attendant know that. She will let you use your phone. When you've finished, you'll give it back to her and resume your deliberations. Deliberations can only happen when all of you are together. If someone needs to use their phone, use the restroom, step outside to smoke a cigarette, anything like that, deliberations about this case have to stop. You can only discuss the case when you're all in the same room talking about it. Throughout trial, I've been telling you about the admonition. This is the point now where part of the admonition changes. I had been saying, don't discuss this case with each other. Obviously, that changes. I had been saying, don't draw conclusions of any kind. Obviously, that changes. You still can't talk about it with anyone else. You still can't do anything to acquire any information outside of what you got through the trial process. Last thing is, there are 14 of you. By law, we have a jury of 12. We randomly selected who the alternates were going to be. Juror number 31 in the front, ma'am, you will be an alternate. And juror number 48 in the back, in the white shirt, you will also be an alternate. So that means when we're finished here and I excuse the jury, the two of you are released, entirely released from the admonition. You can talk to anybody about this case that you want except the other 12 jurors. You can choose not to talk about the case if that's your choice. If you want to know what the verdict is, write your name and your phone number on your jury instruction packet and give that to the court attendant. After I take the verdict, I will call each of you if you would like to know and tell you what the verdict is, give you a chance to ask me questions or offer any complaints that you have. If you don't want me to call you and you don't care what the verdict is, that's fine. Then don't give your packet with your cell number to the court attendant. Make sure it's clear. The two of you should not express any thoughts at all about this case to the other 12 jurors. When we're done here, if you have anything in the jury room, you'll go in and get it, and then you're free to leave. Go home, go back to work, whatever you need. We will not be calling you back in, and you're released, but just don't express any thoughts about the case, any opinions to the other 12 jurors. The 12 of you should not start talking about this case in any way until the two alternates have left. Okay, I should say, I think you all ordered lunch, and even for the two alternates, if you want to stick around out in the hall, not in the jury room with the other 12, and wait for your lunch and take your lunch, you're welcome to take your lunch on the state. If you don't care, you can take off and skip out on your lunch. All right, I have the verdict form. I am going to give this to the court attendant, and she will take you to the jury room at this time. Again, wait for the two alternates to gather their stuff and leave. If the two alternates don't have anything in the jury room, you're welcome to take off immediately. All right.